Hello, everyone. Good morning, and welcome to our JDPA Compliance Readiness webinar. My name is Gracia White from the Calibra Solutions Limited team. Our webinar today, this morning, is being presented in collaboration with our partners, Data Privacy and Security Advisors, Hart Muirhead Fatta, and the Jamaica Stock Exchange eCampus. So before we start, I will be providing you with a short presentation on my end, and then we'll go into the crux of today. So as mentioned, today's webinar is JDPA Compliance Readiness. Our intention is to provide you with a guide to achieving compliance with the Jamaica Data Protection Act within the 6-month Office of the Information Commissioner grace period. The objectives to provide guidance on available compliance readiness services to help organizations and companies demonstrate their compliance with the JDPA. For example, privacy gap and risk analysis and data mapping, which we will discuss in more detail in the webinar. We will also provide guidance on critical considerations within the JDPA. So for example, the appointment of a data protection officer, data subjects, and what to do when there's a data breach. The agenda for today, so welcome and introduction, which I'm doing. Then we will have a brief presentation from the Jamaica Stock Exchange eCampus on their data protection course. We will have a 10-minute fireside chat on the current status of the JDPA, then a compliance readiness program overview, the critical considerations for the JDPA, a Q&A segment, and we'll close. Our presenters today, so I'll be your moderator. Again, I'm Gracia White. From the JSE campus, we'll have Ms. Shireen Farquharson. Ms. Justine Collins is our partner from Hart Muirhead Fatta, and Mr. James Coons, our partner from Data Privacy and Security Advisors. So before I start, I wanted to give you an overview. We have some new persons with us today. This is actually our second webinar on the Data Protection Act, but for all newcomers, we welcome you. So a little information about Calibra Solutions Limited. So we are a Caribbean-based IT firm in operation for over 15 years. Our specialized experience and expertise is in cybersecurity, where we cover threat intelligence and dark web intelligence and monitoring. We also provide trust intelligence, where data privacy, data protection, as well as ESG and GRC services are offered. Security awareness training, business intelligence and analytics, financial application software, and IT consulting and advisory services. As mentioned, we are a Caribbean-based firm. At present, we have over 40 customers across sectors ranging from energy to financial services, including commercial and central banks, public utilities, telecommunications, real estate, and manufacturing. Our commitment to our customers is simple. We leverage technology to accelerate change, to unlock yours or theirs business's success. Our contact information is in the footnote below. You can find us at www.calibrasolutions.com. You can email us at info@calibrasolutions.com or contact us. Note it's a Trinidad number, so +1 868 221 6831. And of course, nothing is possible without the immense support of our partners who extend their technology and business capabilities to provide a powerful ecosystem of market leaders, innovators, and experts. Our partners include Darktrace, Searchlight Cyber, Data Privacy and Security Advisors, and Hart Muirhead Fatta, who we have here today, OneTrust, KnowBe4, Mimix, and Click. And I'll now hand over to Ms. Shireen Farquharson from the Jamaica Stock Exchange eCampus. She'll bring us brief greetings as well as to tell us about their data protection course, which is coming up on January 28th.
Thank you, Gracio. Good morning, ladies and gentlemen. Once again, welcome to our webinar. Thanks for taking the time out. My name is Shireen Farquharson, and I'm a recruiter for eCampus, which is an arm of the Jamaica Stock Exchange. Of course, most of you will know that at the Jamaica Stock Exchange, we assist in keeping companies compliant and transparent. And it is with this backdrop that I introduce to you our Data Protection Certificate course. Now, with the newly established Data Protection Act in Jamaica, as at December 1, 2022, you find that great emphasis is now being placed on ensuring compliance. A lot of companies did not meet the regulations, and so we now have an extension of 6 months. Now, with this act, it also creates the need in some companies for a data protection officer, and this was mentioned briefly by Gracio. Now, the data protection officer has to be appropriately qualified to act in this capacity. At the eCampus, we offer you, through our data protection certificate course, the opportunity to have dedicated team members qualified as data protection officers, and also to educate your staff on what are the lawful bases for processing data, for them to know the risk and reward of a prudent data protection policy, the trends within the data protection industry, the data protection principles, which will now govern the legal regulation and practice, and for them to understand what are the organization's responsibility under the Data Protection Act. They also have the opportunity to learn how to understand the rights of a data subject, and that is a little new for Jamaica, right? So they now get to understand what the rights are of the data subject and the associated implications as a result of the Data Protection Act. The importance of obtaining consent, which is something that is also foreign to Jamaica, is one of the things that's brought to the fore, among other things, right? Our data protection certificate course is a short course. It is also done online and will last 6 weeks. It's reasonably priced at just 65,000 Jamaican dollars plus GCT and a registration fee of $2,500. This course is CPD certified, and our lecturer is very knowledgeable in the area. She's Attorney at Law Justine Collins, and she will also be a presenter on this webinar. As mentioned by Gracio, our next cohort will be starting on January 28th. And I do encourage you to have your team members and yourself enrolled in this cohort. And this cohort really came about based on demand, because a lot of persons just were not ready and needed to have team members ready. So we were oversubscribed before. So I encourage you to put your applications in as soon as is possible to be a part of this group. If you have any questions, you are welcome to contact me on 876-833-9311, or you may email me at Shireen, that is SHERENE.Farquharson, FARQUHERSON, at jamstockex.com. I thank you for your time and hope you will find this webinar to be helpful to both yourself and your organization. Thank you, Gracie.
Thank you so much, Shireen. So just to repeat Shireen's key points, the data protection course will be available from the 28th of January. Information on Shireen's contact email address and telephone number will be shared in the emails that will be sent to all attendees today, as well as a link to the application form. In fact, we will place the application form within the chat so everyone can have access to it.
Thank you, Gracie.
Thanks again, Shireen. So now we move to a quick fireside chat. I invite Justine and James to join me on screen. Hi, James, Justine, good morning. So wanted to just bring everyone in alignment with where we are. So the Data Protection Act was formally implemented on December 1st, 2023. However, today, January 17, 2024, there's still not a lot that can be done within the OIC website. So James, Justine, I wanted to just talk about where things stand based on communications from the commissioner as well as the minister, just to give individuals here and companies, organizations guidance on what can happen right now.
Well, thanks for that, Gracie, and good morning, everybody. It's a pleasure to be here. It's always a pleasure to be with Calibra, DPSA, and the Stock Exchange crew. And James, of course, you can jump in at any time. I think that where we're at is that there was a realization that, you know, December 1, 2023 was a little too close. Not everybody was ready. And so the Information Commissioner has graciously given some more time to persons to be able to register and to be fully compliant. What we saw coming out was a gazette, which brought more sections into force. And then that gave us some clarity as to what that phased implementation will look like. And so we do have the Office of the Information Commissioner website up, but not all aspects are ready. You can register for an account, but you can't register as a data controller just yet. We're watching and just making sure that as things develop, we will keep everybody informed. James?
Right, totally agree. Thank you, and good morning, everyone, as well. To add on to what Justine is saying about the website being up, I think of particular note, one thing that is up is to file or register a complaint. So they have that piece up and working. So we want to definitely keep that in mind as we navigate through this grace period. There's press releases on the website as well, where you can read the commissioner herself's comments about not using this grace period to sit around and do nothing, to continue your compliance efforts, so that you can demonstrate compliance with the Act as early as possible, despite the extension that we've been given. It's an interesting time. A lot of new privacy legislation in the last several years has been enacted. This is the first time that we've seen a lengthy extension like this, so it's hard to say how the regulatory side of this will react in the coming months. But it's definitely it is definitely nice to have this amount of time to continue assessing our organizations, assessing the use of personal data, and looking for the gaps that we can remediate in order to demonstrate compliance.
But just because there's time, which is always a good thing, it doesn't mean one should waste the time. And so even though, again, there's 6 months, we really encourage persons to get cracking immediately. So James, and we'll segue into your formal presentation now. In terms of becoming compliant, we, Calibra, DPSA, HMF, we offer a compliance readiness service to help, or I should say a compliance readiness program to help companies demonstrate their compliance with the JDPA. So I'll allow you now to walk us through what those services entail, and again, to use the time, the grace period, effectively and efficiently. Thank you so much as well, Justine. We'll rejoin you after.
Excellent. So what I want to kind of start out with before I share my screen here is just a quick overview. One of the things that we're doing in Jamaica now quite frequently is conducting assessments for organizations. This is a pretty in-depth, and I'm going to show you a little bit of it. We're not going to go step by step through everything, but I want to show you the technology that backs our assessment methodology. I'll show you an example of some of the deliverables that you would receive. But basically, very common for our organization right now in Jamaica to be doing these, what we call readiness assessments. think of it as a gap assessment, where we've taken the act and we've created an assessment which can be answered by one or multiple stakeholders within an organization. We take those answers, any comments, any other information that might be furnished. That could be any policies, procedures, data maps that may have been done, anything of that nature. And we'll take all of that information, put it into what we internally call a consolidated findings grid. And then from that findings grid, we'll create a pretty detailed report, which is going to give you kind of a snapshot of where you're at, all the gaps that were identified. And along with that report, you'll get a prioritized roadmap of remediation. So you'll receive basically a to-do list. And while remediation is not included with this type of project, it really gives you a good idea of what you need to do in a prioritized fashion. We also give an estimated level of effort to implement any control or remediation that you need to. So with that, I'm going to share my screen now. We basically start out our journey in these assessments with what we call an automated assessment using privacy technology. And as I stated, this assessment could be assigned to one or multiple stakeholders within an organization. And what that basically looks like, and I'm kind of navigating, if you can see my screen, through our privacy technology, but you'll see I'm in what we call the assessments module. It's now called PIA DPIA automation, but you can do more than just impact assessments. Really, any kind of assessment that you would want to conduct, you can do through this. What we would do is we would launch an assessment. And as you can see now, we have various templates. These were all created by us. Some of them just for demonstration purposes. Basically, this whole setup that you're seeing is all just demonstration stuff. But it is based on the real deal. So you'll see that we do everything from Brazil, India, we do healthcare stuff. There's ESG. As Calibra mentioned, we also can help you assess your ESG programs. But what we're really interested in is looking at the Data Protection Act, and we have a readiness assessment for that. We would select that. We would give it a name. We would assign it to somebody. In this case, I'm just going to assign it to myself, and we would launch it. And what that does is it allows the system to email whoever it's assigned to. That can be anybody in the company. And it's going to start asking them questions. It's going to give you some text. This is actually a live version. So we start out pretty simple. Do you have fewer than 250 employees? And do you process personal data? Now you see that I answered yes or no to this question. You see no follow-up questions. If I answer yes, you'll see that it's starting to ask me more questions. Depending on how I answer, you're seeing questions appear and disappear. The entire assessment is built that way, so that if there are certain items that we know, if you're not located in Jamaica, we need to dig a little bit deeper and ask some follow-up questions. And if you are, then we know that compliance, demonstration of compliance is necessary. This is broken into several sections. We'll talk about records of processing activity. We'll talk about the principles of processing and what we heard earlier about the legal basis. We'll ask questions about that. You don't need to be an IT expert. You don't need to be a compliance expert. All of these questions are designed to be answered by really anybody in the organization who's using personal data. And once this is all done, we'll come back into our system and we'll have them all here in various stages. So it might be in progress, it might not have been started, it might be completed or under review. All of those things we'll pay attention to on a pretty constant basis. Daily updates will be sent, and we'll take all of these once they've gone under review, we'll review them. A lot of times we'll reach out to the folks that have answered the questions because we might have follow-up questions. So we do little quick interviews with them to kind of, button up any further information we might need. And then it'll go into the completed stage. Once it hits the completed stage, I'm going to show you something different. We then build what we internally call a consolidated findings grid. This is where we take all of the responses and to every single question with any comments, and we create what we call the assessed conformity finding. So this is just sample data. It's not real, but this is what the document actually would look like. So for question, the first question, these are all kind of qualifiers. But when we start getting into the, do you have records of your processing activities? We'll see that a lot of no answers there are non-conforming. So the assessed conformity is that it's not conforming. We'll have recommendations on what you need to do there, the level of risk, and the level of effort. And as you can see, that is for every single question in the assessment, we have that information. I'm not going to make everybody read all of this, but I did want to show that every single question is taken into effect or into account, and recommendations are given in this document. Once that's completed, so we create our consolidated findings, we then start working on the kind of executive report side of things, or the final report, if you will. And I want to show you an example of what one of those looks like. So this is what a final kind of report would look like. Would have, the client's name. These are all customized. We do start with a template, but in every case, regardless of the size or scope of the business, in every case, the template is customized for that particular client. You'll see here a table of contents. You get an overview of the Data Protection Act. We're also able to do assessments that have multiple regulations. So if you're doing business in Europe, we could combine the GDPR into the assessment, and you'd have kind of a hybrid assessment with that. Or Brazil, we could do LGDP with it. So keep that in mind as well. If you're doing business all over the world and you want to demonstrate compliance in multiple jurisdictions, we're able to do combined assessments. A lot of these privacy laws and regulations share a lot of the same principles, and they share a lot of the same requirements. So doing a combined assessment really helps get you a global program. You'll see here that we go and do an overview of your findings. We give you a roadmap to your compliance. We give you an overview of the methodology, basically what I'm talking to you about today, any caveats or limitations. And then we include the findings grid within. That's a little bit different than what you see in the Excel sheet, and I'll show you that. We'll then give you, we attach the findings grid in the appendix. We'll give you overviews that we write and maintain of any legislation. So in this case, it's both the GDPR and the Data Protection Act in Jamaica. All of that's kind of broken down. And I'll scroll through the report. You get an executive overview. You get a short overview of the Data Protection Act. You get a breakdown of who we spoke to within your organization. So management, IT, HR, research development, merger acquisition, sales, you get the idea. We talk a little bit about managing your privacy program and how to get started on that. Now we're going to talk about your findings and how we identified privacy risk at a high level, where your risk lies. We break that down by section. And then we start getting into your next steps. So managing your compliance and the roadmap to get there. This is a very high level list of your gaps, broken down by high, moderate, and low. We also have priority 1, 2, and 3. We're explaining those here in this matrix. And then from there, we kind of give you this, you know, year-long roadmap, right? And you can adjust these dates as you see fit, but basically, this is a high-level project plan to kind of help you get started. If we were to do an organization's remediation, this would all go into a project plan, and something like this would become a Gantt chart with tasks and milestones. This is meant just to get you started. As I said, you get an overview of the project, how you compare to other companies based on empirical data. That's sometimes very helpful, letting you know where you stand. Any caveats and limitations. So that's going to be us saying if you need legal advice, you need to speak with Justine. And now you get the findings grid in the report. And again, this looks a little bit different. This is just giving you the assessed conformity, as well as the risk, and recommendations are a little bit more formalized here. But you get every single question there. In this report, we'll then give you your findings grid. That's that Excel that would be attached to this report. We'll give you a breakdown of any legislation that was taken into account in the report. So here's just a very short write-up on the GDPR, because in this example, the primary focus was Jamaica. And now you see this overview. This is actually written and published by DPSA. It will, as case law occurs, this will be populated. So this document is a snapshot. You'll receive it, you know, in its current form, but it gives you a breakdown of the entire act, more or less in layman's terms, a little bit easier to understand. We break down the principles, we break down the legal bases, anything you need to do in the event of a data breach, anything governing data transfers, impact assessments, we give you the particulars there. So that's included. You can see that's a lot longer than the one for the GDPR, but that's what the report would look like in the end. One last thing that I would like to show you, as I said, we use technology, and I think a question on everybody's mind lately is registering with the Information Commissioner. And we know that that's not yet available on the website, but what we've done here internally, we've actually created, and I'm going to bring that up now, our own kind of registration facility that allows companies to register or at least gather the information required for the registration with the OIC. This basically is going to ask you for all of the registration particulars. So you'll see there's a lot of you know, text boxes where there's things required, your type of business, you know, telephone number, all of that type of things. If you have a data protection officer, you know, yes, no. If you answer yes, it's going to ask you particulars about them. But this kind of covers everything that you would need, all of the information that would be required currently to register with the Information Commissioner, and then in the end, generate you a formal report. We are in contact with the ICO to see if this is something they would be interested in connecting with electronically, so that once companies hit submit, they would actually receive that information, and then the OIC would then work out how they would accept payment. But right now, that's really not their focus. Their focus is getting their own registration form up. But once that is up, you'd have the report that would be generated by this that you could simply copy or paste, or hopefully upload online to complete your registration without having to collect or verify everything 2 or 3 different times. So that's the methodology. That's the technology behind everything. In the interest of time, I'll wait till the end when we have Q&A, but I wanted to show you kind of how our process works to do these assessments. There's a lot that goes on. When we do the consolidated findings, we have a group of privacy experts that are reviewing everyone's responses, and we do what we call a peer review. So there will be someone involved in the project that doesn't necessarily ever talk to the customer. So when they see the findings, they're looking at it for the first time to give them a clean perspective. And then they'll basically argue and haggle with the consultant that's been assigned to do the assessment, to kind of answer questions, maybe play the devil's advocate, whatever it takes to get a very good, clean, consolidated finding. And with that, I'll hand back.
Thank you so much, James. That's actually a perfect segue to two poll questions that I'm going to throw out to our attendees. So the first question, and it supports the last part of your presentation, James, in terms of the registration itself. So poll question number 1. And that question is, how prepared is your company or organization? And we've got some good options for you. So are you compliant? So you've created your account, you're ready to go. Are you somewhat prepared? Are you not prepared? Are you just out of the loop? You have no idea what's happening? Help. So I'll leave it on screen for a few more seconds. I'm seeing a lot of somewhats and a few nots. Some good, we are compliant, which is great. It just means that once more sections are available within the OIC website, it can be completed very fast.
Correct.
Okay, so I'll close off this poll question. Thank you so much to the TCJ team. And the second poll question that I have, so based on what you may or may not know about the JDPA and the registration process, which requirements of the JDPA concern you the most? So I'll repeat the poll question number 2. So which requirements of the JDPA concern you the most? Is it the registration process, appointing a DPO, data subjects, data subject access requests, privacy programs, DPIs, data breaches, everything? Please share your feedback. And just in case the polls are anonymous, you will not be punished for any questions you answer. Please, I want as many of us to participate. I'm at about 46%. As many of you, please answer the poll question too. All right, so far, and as I segue into Justine, I'm seeing a few DPI queries coming up here. I know that's an area that you and I have spoken about separately. Also building a privacy program, there's some doubts about. All right, so I'll end off poll question 2, so we can bring Ms. Justine Collins in. So I'll mention, as Shireen indicated, that Justine is also the lead on the data protection course. She's also a partner at Hart Muirhead Fatta and a great member of the team. So Justine, critical components of the JDPA. What can you tell us about that?
Okay, good morning again, everybody. Thank you so much for having me. It's always a pleasure to come and present. So I think James did a really good introduction into what their data protection assessment, their gap analysis really looks like. What we will be looking at today, we've looked at the Data Protection Act and key provisions in previous webinars, and so we're going to switch it up a little bit. What we are going to be looking at is compliance issues that are raised from the Data Protection Act. So we are going to look specifically at how we can operationalize that. So critical considerations for the Data Protection Act. And we are looking at, in terms of our overview, the 6 topics we'll be looking at today are, I think, what we would say frequently asked questions in terms of when we do our engagements with clients or our trainings, just some of the questions that we get frequently from the audience. So the first one is data controller versus data processor versus data protection officer. What do these things mean? Where do we start? It just seems like a different language to me. What do we mean when we're talking about those 3 terms? Secondly, we're going to look at how to register as a data controller. We're also going to look at how to prepare a privacy notice, which is a very important document. Then we're going to look at data subject rights requests, which I find is generally overlooked as a compliance issue. And then we're going to segue into data breaches, which is very much a topical issue. If persons are not compliant with the Data Protection Act, a lot of persons have experienced at least one data breach. And you may have experienced a data breach and you don't even realize that it really was a data breach. And then finally, we're going to look at key clauses for compliance. It's a 100-page act. What we're looking at are just some of the key provisions that you will need to know in order to be compliant in terms of operationalizing. What are the key provisions that we need to look at? How do we do this, right? All right. So let me segue. So data controller versus data processor versus data protection officer. And remember that at any time you can go into the Q&A and ask any questions if it's clear or unclear rather, or you want to just kind of go over something. All right, so data controller. What do we mean by a data controller? What does this term mean? So a data controller can be a natural person. And when we talk about a natural person, we're talking about me, Gracia, James, all of us are natural persons or legal persons. So those persons can be a company, a large company, a public authority, the Administrator General, the Company's Office of Jamaica, Grace Kennedy, JPS. All of these are legal persons who either alone or jointly, because you can have joint controllers, determine the purpose and the manner in which personal data are processed. So the key consideration for this is to determine, is this entity a data controller? What are they doing in relation to the processing activity? Are they determining the purpose and the manner in which personal data are to be processed? So if you have a business that is, for example, let's say they are a large bank. If they are bringing in customers, you sign up with an account, you fill out a form, you open your savings account, they take all your information, your name, TRN, address, letter from your employer, etc. They are saying, look, we need this information in order to provide you with an account. And so we are determined, that bank is determining the purpose, the reason, and the manner in which it's processed. That bank would be a data controller. Now, this is very important because I've had persons come to me and say, Well, we think the CEO is really the data controller. That's not correct. The CEO is a representative of the data controller. So in that type of situation, the data controller is that bank, right? So the data controller would be required to register with the information commissioner. And of course, right now you can create an account. In a couple of slides, we'll look at how you can go about doing that to the extent that it's possible right now. Now, a data processor is slightly different. A data processor is any person who processes data on behalf of a controller. So let's go back to that bank situation. You have a bank, you open an account, fill out the forms, and let's say the bank has a software provider. The software provider actually provides a system that makes it easier for them to create an account, do a KYC, or know your client check on this customer to say, okay, is this person on the sanctions list, or is this person somebody that we don't want to do business with? That software provider would be a data processor because they are not determining the manner and the purpose of the processing in that specific activity. They're providing a service on behalf of the controller. The controller is the one that's instructing them, this is what I'd like you to do, right? So in those circumstances, that provider would be a data processor. If you outsource payroll operations, that's a typical example I give, that's a data processor. Then your employees are not data processors. Your employees are representatives of the controller. So data controller, data processor. Great. Now your data protection officer is a little different. Now section 20 of the Act speaks to you appointing. The controller is required in certain circumstances to appoint an appropriately qualified person to monitor in an independent manner the controller's compliance with the provisions of the Act. So the data protection officer is an officer. It's a representative of the data controller, and it's a statutory position. So they're required to monitor the controller's compliance. So they oversee, they supervise, they look and they say, okay, well, there are certain things that we need to do a little bit better in terms of our privacy compliance. There are certain, they need to also be accountable to the information commissioner if there are any questions or requests that are made. Now, not every controller is required to appoint a data protection officer. If you're a public authority, so if you're a government agency, ministry, etc., you are required to appoint a data protection officer. If you process sensitive personal data, that's when we're talking about health data, biometric data, genetic data, political affiliation. Any kind of data relating to that is sensitive personal data. If you collect that type of data, you are required to have a data protection officer. Or if you process data on a large scale. Large scale is something that we've gotten some guidance from the Information Commissioner in terms of what that entails. But those are the categories of persons who are required under law to appoint a data protection officer. Critically, with the data protection officer role, why it is very, very challenging for some people to grapple with is this concept of independence and conflicts of interest. And if you look at the second bullet point, you'll see that it says a person shall not be qualified to be appointed if there is a likelihood of a conflict of interest between that person's duties as a data protection officer and any other duties. So if you as a controller are appointing an employee, an existing employee, as a data protection officer, you need to critically examine their existing roles. Are they in a position to determine the purpose and manner of the processing for the controller? There's a recent case from Europe, which speaks to operations, chief operations officers. Those are not persons that would be well suited for a data protection officer role, because those are persons who likely would be saying, look, we need to be doing this as an organization, that as an organization. These are the things we need to be processing. And so they would be in a position where they are determining the manner and purpose of the processing. And that could likely conflict with something that's a person who needs to provide oversight. Similar to kind of an audit type of role, but not specifically like that. But that's what you're looking at when you're thinking about appointing a data protection officer. So critically, and this I think is coming from the Information Commissioner's Office from June 2023. The data protection officer has certain roles. They need to ensure that the controller processes personal data in compliance with the Act and the standards. They need to consult with the Information Commissioner in respect of compliance. That data protection impact assessment report that we spoke about, that's to be submitted annually, and they provide a critical role in terms of assisting with that. In terms of a data breach, which we'll talk about in a couple slides, they assist with that management and then generally monitoring compliance with the Act. So if there's any new things that come out, if there is any guidance that comes out, they want to be kind of keeping abreast of that information. They're sort of a privacy ambassador for the organization. Oops, sorry, I jumped ahead there. And so there are really 5 things you want to think about when you're talking about who can be this data protection officer. You want to be looking at whether or not that person has familiarity with the business and is accessible. Is it somebody that people can approach and say, hey, you know, John, I was wondering, I wanted to do this and that. Is this okay from a privacy point of view? They also want to have legal knowledge and or specialized privacy training. So Shireen would have talked extensively about the Jamaica Stock Exchange eCampus's data protection program, which is part of their larger diploma. And that's something that you can also consider in terms of if the person is not an attorney or doesn't have legal knowledge, they can always get specialized privacy training from the Stock Exchange eCampus or another provider. Audits or compliance experience, that of course will be very helpful in terms of ensuring that the organization is compliant. Technical skills and independence, very important, and excellent communication skills. In one organization I did a training for, they called their representative a data protection champion, which I thought was really great. I was like, this definitely engenders some, you know, familiarity and the communication really was there because I felt, okay, yeah, we can talk to our champion if we have a problem. All right, let's just segue into one of the bigger items, how to register as a data controller. So while we don't have the registration portal as yet, we do have some information on what we need to register. Now, it's important that when that portal is live, we know that we have to register because if you're not registered, it may constitute an offense. You are required to register the name of the controller, the purpose of the processing, and you also need to state whether or not there's any data transfers. There, of course, is a fine if you do not register. And I would just like to point you to some of the fees that we are aware of so far based on the draft regulations. So in terms of registration fees, it's $25,000 for a company. Partnership is a little less, it's $15,000, and sole trader, of course, is $7,500. And then aside from you registering, there's an annual fee that you'll have to pay. And so far, tentatively, based on the draft regulations, it's $15,000 for a company, $10,000 for a partnership, and $5,000 for a sole trader. These are in Jamaican dollars, just in case anybody is tuning in from overseas. This is Jamaican dollars. I should have put the Jamaican dollars on it. So just segueing to the next, oh, right. So we would have spoken about the fact that the Office of the Information Commissioner's website is live. You can check it out at oic.gov.jm, and this is what you will see. And we spoke about creating your account, which is the first step. So while you can't register at this point, you can create an account so that once the registration portal is open, you already have your account live. And of course, if it is that you have a data breach, creating this account will also assist you in terms of reporting that data breach. So I would encourage you to familiarize yourself with the website and create an account if you haven't as yet for your organization. How to prepare a privacy notice. So also a very big ticket item, but let's talk about this generally. What is a privacy notice? What do we mean when we're talking about a privacy notice? Is it like, it sounds very abstract, but a privacy notice is basically an external document which explains to clients, customers, website visitors, vendors, any other person who comes onto your website, what do we do with your data? So we are X Limited. We're committed to providing to preserving your privacy. And because of that, this is the type of data we collect from you. And this is the reason we do it. These are the persons we possibly share it with. These are the legal bases. James spoke about the legal bases. These are the legal bases for sharing. And we're being transparent with you. And so it forms part of your larger fair processing obligations. And it gives persons a sense of, okay, it's very, very transparent. We know what they're doing, and we have a sense of comfort. So what does a privacy notice entail? What is required, rather, sorry. So Section 22(6) of the Data Protection Act basically goes into what that privacy notice would need to have. You need to identify who you are as a controller. X Limited, our data protection officer is John Doe, or any other representatives. You want to talk about why you're processing the data. We process the data because we are a bank and we are trying to provide you with financial services, right? We might share, who would you share data with? You might share data with law enforcement, as required by law. If you're a bank, you might need to let persons know, let the FID know, let the ministry know, whomever, the Bank of Jamaica, etc., that this information was collected or this person has certain KYC issues. Consequences of not providing the data if required by law, the legal authority or the legal basis for seeking the data, how long do you expect to retain the data, and any other information that may be necessary, right? Oh, I skipped ahead. I'm sorry, I got confused because the pictures look the same. All right, so what are the steps? How do we do this? I think that the best way to start is to conduct a privacy assessment or a gap analysis, and you can consult a qualified person. You do have some expert persons here already. Calibra, DPSA, they are great at what they do. And so typically you want to start with an assessment. And then in that assessment as well, likely will identify which data protection laws apply to you. Then you want to kind of do a data mapping exercise if you haven't done it already. So you really want to understand where your data resides and what you do with it. Okay, when it's collected, where does it go from here? And what's the reason for us collecting it? And where does it go from there? And sort of all along the chain. And then that would give you an idea of, okay, in us formulating our privacy notice, this is what we need to account for. Categorize the personal data you collect and process. So is it just personal data, name, address, or is it also sensitive personal data? Do we have health data? Do we have information on religious beliefs? That sort of thing. That is sensitive personal data. And that, of course, would fall within the Data Protection Act. If you need to identify the purposes for each collection and the legal basis, identify how you use the personal data, identify any data sharing practices, identify your data subject rights request procedure, which we're going to go into in a couple of slides, any safety and security practices, and your data protection officer. And then once you gather all of that information together, you're going to draft your privacy notice. And I'm going to look at it and be like, oh, this is so transparent. I love this. And it gives us a sense of, I went to the doctor the other day and you know, she showed me her privacy notice, and I was like, oh my gosh, this is the first doctor I've been to that has a privacy notice. And it just made my day, because I felt like my data she cared about my personal data, and she cared enough to, you know, walk me through it. And so it creates a permanent customer in me, because I'm like, oh, great, she really does care, you know? So definitely consider these steps to preparing a privacy notice. I think it is good to start with a consultation. Data subject rights requests, very, very important, often overlooked. Now, what is a data subject? We talked about data controller, data processor, data protection officer, but who are we talking about when we talk about a data subject? That is the named or otherwise identifiable individual who's the subject of the personal data. So that's me, that's James, that's Gracia, that's Natalie. We are all data subjects, and we have rights under the Act. All right, so I'm going to just go into some of the rights that we have in our legislation. I'm going to focus mostly on our right of access, because that's the one that right of access and the consent operationally, I think, would be higher priority from our perspective. So your right of access, you as a data subject, so any person can say to a data controller, look, can you tell me what information you are processing about me? I would like to know, you know, what information you have, what are you doing with it, why are you using it, etc. And for you to actually say, okay, no problem, Justine, let us assist you in exercising your rights. And remember, you do have 30 days to respond. You now need to have a process like, okay, where do you start? Where is the data? Have we covered all of our bases in terms of analyzing and putting it together? And then what if she wants a copy of it? So you need to have a process around how you're going to operationalize all of that. So how are you going to do that from beginning to end? So your data mapping and your data inventory exercise is very, very crucial, because then you have an understanding of where your data resides in the organization. Some persons I've seen have manual forms, and it says, if you would like to exercise your right of access, you can fill out this form. It asks you for your ID, your name, etc. And then it goes through the system. It probably goes directly to their data protection officer, who's then able to consult with IT or whichever department to pull all the information together and provide it within an intelligible form within the 30 days, right? But you have to have a process. Other persons have tried to automate it, which is great. James earlier would have spoken about OneTrust, which is one of the privacy technology tools that seeks to automate those kinds of rights procedures. But it's not the only one. So you certainly can say, look, 30 days sounds like a long time, but in the business world, it's not a long time, right? So you certainly want to have a very easy process to actually do it. And then you also want to make sure your external facing staff know how to assist somebody who's dealing with that, because then they would be like, right, well, I don't know what you're talking about. So you don't want to be in that kind of position, because then it shows a sort of gap. Persons don't know about how persons can exercise their privacy rights, right? The other one is consent being required for direct marketing. So this, I think, is another big issue for persons. If you're direct marketing, when we talk about direct marketing, we're talking about the ones where I get these really nice text messages that make me think somebody special is messaging me, but it really isn't. It's just one of the larger telecommunications networks sending me ads and saying, oh, yes, so-and-so is having a sale today, make sure to go on. And I'm like, oh, okay. It's not that person, it's just an ad. So that's direct marketing. It's when it's directly targeting me, you know? You need to get consent for that. So you need to put in protocols in place to say, okay, when this person gives us their data, we need to see whether or not they agree for us to directly contact them. And then directly contact them in what medium? Do you want to be contacted by text? Because I always opt out of text. I don't want nobody to text me. But emails, maybe, yeah, I would like to know if you're having a sale, I may come down, and don't call me. So you want to also have that ability to opt out a different medium, you know? So you might want to do text, but not really calls or emails or the other way around, right? So that procedure is really important. And just to touch on some of the less priority procedures, you need to have rights that, well, sorry, data subjects have rights to prevent processing that may cause substantial damage and substantial distress. That, of course, might arise in situations where persons circulate sort of traumatic images on the internet. Certainly, that would be a right that's exercisable then. Rights in relation to automated decision-making. All the AI that we're going through right now, I'm sure that we are going to have more of these rights requests being made, saying, look, can you not make these decisions solely based on automation? And then, of course, your right to request rectification of inaccuracies. Most places already have some sort of procedure for this. For me now, I always get the Justin Collins. The other day, somebody said, good day, Sir Collins. And I was mortified because I was like, please, you've misgendered me. So certainly I said, look, my name is Justine, I'm a female. And they corrected it, but they have a procedure already. And most places do have a procedure, but it is a right under the Data Protection Act. All right, before we go to the last issue, I know I'm running out of time. I don't want Gracia to kick me off. So data breaches. Now, data breaches it's very, very, very big. Somebody had said to me, look, it's not a matter of when, of if, but really when, you know? When will you have a data breach? Now, a data breach is a breach of confidentiality of information. It can be a security incident or a cyber attack that results in a security violation. Now, data breaches can range from something as simple as you losing a USB, somebody breaking into your car and your laptop with all this personal data being stolen, to a very, very severe ransomware attack where they come in, they infiltrate your systems, they shut down everything, and you can't do any business because everything's on a particular server, and so business has been disrupted. A lot of people don't realize that you simply sending an email with personal data to the wrong recipient is a data breach. So it's very important for you to be mindful of just the level of risk that can occur. It could be, you know, very minor, very low risk to major business disruption, ransomware attack, etc. So can happen through human error, malware, malicious insiders, all of that. So the question is, what do we do when there's a data breach? What are our next steps? So typically, and what is important is that you should be thinking about what our incident response plan will be. A lot of organizations have incident response plans for hurricane, earthquakes. We had a big earthquake last year, fire, those kinds of disasters, but not many have for cybersecurity incidents or data breach incidents. And if they do for cybersecurity, they may not have for data breach. And so I'm encouraging you to think critically about your incident response plan. Typically, when you see an incident response plan, you want to alert IT and they will do whatever it is to isolate the incident. You also want to be consulting with cybersecurity experts and just ensuring that you're understanding what the type of incident it was. Involve senior leadership, alert legal, depending on the risk, because lower risk may not necessarily require all those types of, oh my gosh, we need to get everybody in, right? It's always good to engage external counsel if you find that it's a higher risk. And then if you say, okay, well, we've determined that there was a cybersecurity incident and there's a possible data breach, you do need to report to the Office of the Information Commissioner within 72 hours. And you need to also think about whether or not you need to report or notify rather the affected data subjects, right? Within 72 hours. So all of that needs to go in terms of going to the process in terms of addressing the data breach. And of course, documenting each step. When you do the report, typically the Office of the Information Commissioner wants to know, okay, well, what is it that happened? What type of incident what type of incident occurred? And is this a preliminary report or are we going to get more information? So you don't have to feel like, well, we don't have a report in the 72 hours because we really don't know the full extent. You can do a preliminary report. And I'd encourage you to do that and say, look, we're going to do further investigation, but we're just letting you know. You also need to consider whether or not if it was a cybercrime, you should report it to the relevant authorities. So MOCA, CTOC, Cybercrimes Unit, FID if you're regulated. And then of course, if you are regulated by specific regulators, think about whether or not the Financial Services Commission needs to be notified, the Bank of Jamaica, the stock exchange, if you're a listed company, because there might be some obligation to let them know any operational risks. So definitely something to consider. And then finally, key clauses for compliance. So as I said, it is 100-page, it's over 100 pages, I think the Act is. And I know it can be a little overwhelming, but what we've done here is we've identified some of the sections of the Act which are key for compliance and are key to operationalize, right? So James would have talked earlier about lawful basis or legal basis. Typically, a lot of persons use consent, but we know that consent is not the only basis, right? In terms of how do we lawfully process this data? Great if you can get consent, but sometimes consent is not appropriate. We talked a lot about the bank today. Sometimes the bank may require information from you that are in relation to their proceeds of crime obligation. So we need to know who you are so that we are not facilitating money laundering, and that is required under the Proceeds of Crime Act. And so we don't really need consent from you because at the end of the day, it doesn't matter if you consent or not, this is the law. So that ground it is required based on a legal obligation to which the controller is subject. Vendor management, very important. So your data processors, you do have a section within the Act that requires you to have a contract with sufficient guarantees in place that, look, in a data breach, we're going to let you know that this situation has happened. You don't want a situation where you have a software provider who 6 months later has told you that there was a breach. And I've seen it happen, which is just insane to me. You want to be able to say, look, no, you were required under contract to do this. And you want to look at your contracts to see whether or not you need to put in an addendum to make provision for that. Retention is also very, very important. You don't want to be in breach of any of the standards. And so not keeping the information for longer than is necessary and putting retention periods around your data is important. We spoke about incident response, which is important. Your data protection impact assessment under Section 45. Each year, you are required to send a data protection impact assessment report. to the Office of the Information Commissioner that really speaks to your processing activities. We spoke extensively about registration in section 16, as well as data subject rights requests from section 6 to 13, and your fair processing obligations or your privacy notice. You're not going to see the word privacy notice in the Act, but it's implied based on the wording of section 22.6 that you need to give persons this information, right? And so this is just a broad overview of some of the notices and policies that you may be considering in your organization in terms of compliance. We spoke sort of generally about them, but of course, when you have a look at it after, I'm sure it will kind of make sense. So I think I've run out of time, but thank you for having me. And if there are any questions, I will be happy to respond.
Well, I'll let you stay on screen because we're gonna go into Q&A. I have
Okay,
one more
great.
poll. I have one more poll question to launch, which simply asks to our attendees if they are interested in JDPA compliance readiness services, and if so, which services in particular. So are you or your company or organization interested in JDPA compliance readiness services? And if so, which services in particular? So Justine, whilst the poll question is going on, I received a question with respect to the privacy notice. If there was an example that could be shown, I don't know if you have access to one on hand. If not, just to reiterate, like the key components that should be included in a privacy notice.
I'm so sorry. I did not realize I was on mute.
Figured.
I'm so
Okay.
sorry about that. All right, so sorry about that. I was answering. So a privacy notice is usually tailor-made for your organization because at the end of the day, remember that it's reflecting your data sharing and your data processing activities. What we did here is we just showed you, like, typically, this is what a privacy notice entails. If you go on the Office of the Information Commissioner's website, they have a privacy policy, but a lot of, especially when you look at websites from the UK, the EU, they have privacy notices on most organizations' websites because they are, of course, subject to the General Data Protection Regulation, which we didn't get into much today. So certainly you can have a look at that and any other privacy compliance organization here in Jamaica and look at what they have. If you're looking at it for your specific organization, I would recommend that you look at an organization within your industry, because at the end of the day, the privacy notice is going to be tailored, customized to what they do. In my course, I usually use the BBC privacy notice. BBC has a great example of what's called a layered notice. And it goes into, it does it in a question format. So it says, if I want to exercise a right, what do I do? What do you do with our information when we give it to you? It's very, very easy to read. It's not a legal document. It's very much supposed to give you a good feeling in a sense. It's supposed to make you feel like, okay, this is what they're doing. They're being transparent and they're not hiding anything.
Thanks, Justine. All right, question for James. In terms of registration and like my next steps, actually, Justine, I said it's a question for both of you. Who needs to specifically register? So one of our Q&A questions that came in was, do churches need to register? We also have a few real estate agents, brokers attending. Do they need to register because of the data that they're handling? Also pharmacists?
I can let Justine answer, but if you're
Oh, no, that's fine. I was just catching my breath. Go ahead, James.
if you're processing, personal data, if you're in control, so if we look at the word data controller, understanding that means you're the entity that is in control of the data, you would need to register.
Yeah, so just to add to what James is saying, so basically, once you have a personal data implication and you are a data controller, you would need to register. Churches definitely would need to register, but I think that there is an exemption in terms of data protection officers under Section 20. You'd have to look at that. So if you're a nonprofit, you wouldn't necessarily need to appoint a data protection officer as a statutory person. Certainly it'd be great if you have a privacy person, like somebody in your church that can say, okay, yeah, man, I'm organizing our data protection compliance, and this is for the betterment of the Lord. And so, we are committed to their privacy. But yes, you would need to register as a controller. And of course, you can reach out to us if there is any further questions that are specific to your church.
And I think that brings up a great point. A lot of times, these types of questions, do we need to do this? Do we need to do that? And although the answer a lot of times would be no, I heard Justine mention a few things during her presentation. There are certain things that, number one, are implied that you need to have that aren't specifically spelled out, but they're implied. But then also it becomes about marketable image and being a good steward of personal information, right? A lot of our customers have shifted in the past several years from taking the stance of, okay, I'm going to do the bare minimum to demonstrate compliance, and then that's it. And then what tends to happen as the whole world starts enacting legislation, you're trying to be compliant in Jamaica, you're trying to be compliant in Europe, there's derogations, there's small nuances. So really adopting a culture of data protection, a culture that puts privacy and data protection at the heart is pretty much the right thing to do. So maybe you don't need a data protection officer, but maybe you consider appointing one, if anything, that you're showing your customers or the data subjects that you're handling the data thereof, that you care and that you're actually taking an interest in protecting their information and doing the right thing.
Thanks, James. Great response. I do agree and support the idea of having a culture of data compliance. I just think a culture of compliance in general is very beneficial and necessary. Another question under the DPO subject: can a DPO be in charge of an e-commerce fulfillment team? I'm assuming this company may be a manufacturing or distribution company.
I'm a little hesitant to answer that question just because it is a little hard for us to speculate without really understanding what this person's role is. A lot of times when clients come to us and say, can the DPO be this person? Or my students come to me and say that it's better to, a lot of times they answer the questions themselves because they would have an understanding of the role that person plays within that organization. And so a good example of that is that there was a big discussion in our student group a couple of years ago about whether an attorney could be a data protection officer. And there was, arguments on both sides. And they said, well, our in-house counsel performs more of a compliance function, so we think that she would be appropriate for that. And another person said, no, well, our attorney is really very involved in the business. She's doing, she's not really an attorney. She's more of a head cook and bottle washer. And so she probably wouldn't be the best person. So it's a little hard for us to speculate without fully understanding what the person's role is. And that is a question that we would have to get more information to really say, okay, this is the person's job description, these are their roles, this is who they report to, which is very important as well, that who are they reporting to? Is it just senior management or is it to the board? Because typically you'd want them to have some sort of reporting to the board. So I'm gonna give you the lawyer answer. It depends. So that's the best that I can do. I don't know if James can assist.
Yeah, I think it comes down to what you said earlier as well, right? So there has to be a high level of impartiality, right? So if I'll use the example, if somebody's running an e-commerce team, I have a background in marketing and e-commerce, right? So we're looking at things like attribution and creative ways to use data. So implied alone would be a conflict of interest in itself with just the nature of that job, but as Justine said, without really knowing the particulars of the role and what they do. DPOs really in most legislation that has a DPO requirement, we don't see a very prescriptive set of skills other than they need to have a full understanding. But we definitely do see they need to be impartial. They can't be, you can't retaliate, and fire them if they made a data decision that, would be harmful to the company, right? They're really the advocate for the data subject within your organization. So like Justine said, for us, when we evaluate this question, it really is case by case. We look at not only the job description, but we also talk to those individuals and basically ask the question, what do you do here? And when we further understand that, then we can help answer that question and say, yeah, this person probably isn't the best selection for a DPO.
Thanks, James and Justine. Okay, I have some really good questions in the Q&A. I do want to ask something specific to the compliance readiness services. So, and James, you can take lead on this. So why is an assessment necessary to register with the OIC, and how long does an assessment take?
Okay, so both very fair questions, and I'll start with the first part. Why is it necessary? So the registration particulars that the ICO is asking for is not just your company's name and your TRN and your address and phone numbers and things of that nature, but it's also about your data processing activities. And really with the registration, they're trying to determine, or they want to determine, whether or not you know what data you have, you know how it's being used, you know where it's at, you know who has access to it. So the assessment is designed, number one, to answer all of those questions. And then number two, it's also designed to allow you to say, hey, wait a minute, we have some gaps here. And, before we register with the ICO, we want to be able to demonstrate or show the ICO that we actually have controls in place, that we, sometimes just understanding where your gaps are and actively working to resolve them is sufficient, right? This isn't an exercise of, here's 50 things that are wrong and you need to have them fixed before registering, but at least knowing that you have gaps, knowing where they are, and having a plan to remediate really counts. So it's really serves as those two things. And then an assessment can take, depending on the size and scope of the organization, the availability of personnel, we've managed to turn them around in just shy of 2 weeks. Other times it can take up to a month, depending if we need to do follow-up, if we need to do interviews, if there's a lot of intricate data flows that we need to kind of look into. But generally, you're looking, you know, we always say, well, within a 4-week period for most organizations, you should be able to have a result and start working on the remediation.
For small companies, such as a real estate brokerage company, they may not be able to afford a data protection officer, an internal one. Can data protection officers be outsourced?
So there are rules around that. You know, our organization, DPSA, does not provide DPO services, first and foremost, because the individual would need to be in Jamaica, and secondly, there would be a conflict of interest if we're assessing and helping build and run your privacy program. We wouldn't want to, you know, we wouldn't want to be that person that's interfacing with your information commissioner. We do like to keep that separate. It puts more value in using a third party for that organization, knowing that your DPO is impartial as well as your vendor, right? So what we do provide would be ongoing privacy office as a service, for example. So we could act as your privacy office externally, and we could then advise an appointed DPO. So a lot of organizations that either don't have, or in some cases, like you said, can't afford, if they find somebody internally that's willing to be appointed the DPO, that has, you know, a basic amount of knowledge, they can be trained on the regulation, and they can be supported by an outside firm, whether that's a law firm or a firm like the DPSA. Those options definitely are available. And for small companies, you know, we always find a right size solution that's going to be cost effective to allow them to do that.
And specific to the assessment and the questions that are answered, who does the assessment, and why are, say, for instance, marketing could be involved in the assessment, or IT?
Right. So that's actually a very good question. So who should take the assessment? Really, at the end of the day, anybody who is handling personal information within the course of their employment, right? So this could be somebody in HR that's processing resumes. This could be, like you mentioned, marketing folks who are handling lead data or customer sales data. Really anybody that's handling personal information. We try and limit it. So, you know, when we embark on one of these programs, we would look at where's the most volume of personal data being processed, and who's doing that. So for HR, it might just be 1 or 2 people from HR answering the assessment, but your HR department might have 10 or 15 people working there. But we're really looking for any department within the business that is handling personal information. And in this day and age, that's just pretty much every part of your business. So that's what I mean by looking at volume wise. So if there's a department that only sees a couple pieces of personal information here and there, they might be low priority, and their assessment might be rolled in with another individual. The capability of our technology allows us to assign one assessment. So if we have an HR assessment, we could assign that single assessment to 5 different people and allow all 5 of those individuals to weigh in on the response.
Thanks, James. Justine, I'd ask you to clarify a response you gave. So a question we received: how is the OIC, Office of the Information Commissioner, regulated? So you confirmed that the Data Protection Oversight Committee was appointed pursuant to the Act to oversee the OIC, and decisions can be appealed. But do you want to just add some clarity to that?
Sure. So generally speaking, as with most legislation, there's always a right of appeal in terms of decisions that the Information Commissioner may make. But I think your question really is related to, okay, well, if they are a data controller, which they are, and they're a public authority, how are they kept accountable in a sense? And there is an oversight committee which is appointed pursuant to Section 4, I believe. And there are a set of independent persons. And if you look on the OIC website, I believe it's still there. I know it was on the previous website. The names of the persons on the oversight committee would be there, and they are generally persons. There's an attorney, there's retired persons, there's somebody from government. And so there is the possibility, if you feel as if there's some issue with how the Office of the Information Commissioner has dealt with your data, if they haven't dealt with it directly, then you can always file some sort of complaint with the oversight committee. So that essentially is it. And then of course, in terms of generally, other public authorities are subject to the Office of the Information Commissioner. So yeah.
Okay, where you have a group of companies and one is a listed company with the remaining companies being small subsidiaries, does each legal entity have to submit registration particulars?
I think I know who's asking this question. But I think that the response is that whenever you have a personal data implication and you are a data controller, that is the guiding test. While we cannot give you specific legal advice, because a lot of it is going to depend, all right? You really need to look at what that company, those entities are doing operationally. Are they determining the manner and the purpose of the processing? And so a lot of times when you have these large corporate groups with, some companies are merely property holding companies, and some companies are just are there to pass through, and they have tax efficiencies, and it gets quite complicated. You would need to then assess each company to see whether or not they are indeed controllers. I think I've responded to that person before, and I think I know who is asking it. But I hope that assists you.
Okay, I just have enough time for one more question. So, all right, I'll try for two. Internal customers, how do we go about handling consent, incidents, etc., being an employee as well as a DPO?
Okay, so generally speaking, companies will have obligations to their clients, their customers, their external persons, as well as their employees, because their employees are data subjects. So you would need to have, and if you look at the little table that I would have done, one of the things that, or one of the notices that is out there is an employee privacy notice, which speaks to how you are going to process employee data. So in terms of consent, the consensus in relation to employees is that consent is not really an appropriate basis, because you have a sort of imbalance of power between an employer and an employee. You can say to an employer, I'm not going to sign this document because I don't consent. I think it's very unlikely they will say, do you want this job or not? So certainly most of the good thing is that most of the information that you collect as an employer are usually required by law or necessary as part of our contract. So you want to give them certain health insurance benefits. You want to give them pension. These are perks of employment that you would want to give them as an employee. Sometimes we do see consent in employment agreements that allow persons to be aware of the employee privacy notice, and you obviously want to keep people abreast of how you are processing their data. But generally speaking, it's better to kind of rely on a few more grounds for employee situations. In terms of your customers, I think that's a bit more. It depends, right? So you would want to look and see what you're actually doing with the data and the type of processing activity that you're doing, because it's not a one-size-fits-all. When we talk about legal grounds for processing, we need to look at each processing activity to see whether or not you need to use consent or something else. So it will depend on the activity that you're performing. And when you do say, okay, consent is the best way to get our legal basis, then of course you want to see, how can we get this consent? Are we going to send out a physical form, or are we going to send out an email and ask them to opt in to this processing? So you would have to do a sort of wider assessment of all of your activities before you're able to say, yeah, definitely we're going to use consent. But consent for what specifically?
Thanks. Okay, in terms of the actual OIC registration, if a company requests services from, say, HMF Justine to complete their registration, is their registration then automatically done with the OIC by Hart Muirhead Fatta?
Well, so what we can do and what we haven't done any registration as yet, but let's just start there because the registration is not live as yet. What we have been doing is we've been advising clients on what your registration particulars are and some of the sort of things that are a bit more nuanced. We've been saying, because there's some of them that are very, very straightforward. Name, address, TRN, etc. But then there's some of them saying, for example, what are the legal bases for processing? And you're going to need a bit more legal advice in order to do that. My recommendation has been, create the account. We'll assist you in terms of the registration particulars, and then you can go ahead and register because you just input the information, and that's what we're foreseeing. But because we have not seen the portal as yet, we can't really speak to an automatic process per se, but certainly we can provide you with advice on how to answer some of the registration particulars questions.
Okay.
There's
Go
one
ahead.
other question that I think we should respond to in terms of data protection officer serving multiple companies.
Yeah.
A big issue. So, and James, feel free to jump in as well. But from our understanding in terms of our discussions with the Office of the Information Commissioner, there's a regulation, the last draft regulation speaks to the data protection officer. Yes, you can outsource it, but this person must not serve multiple controllers. And that is something that they apparently do not agree with. And they are hoping that when the regulations are finalized, that it will not be in the final set. So that is that's understand is the consensus of the Information Commissioner. James, I don't know if you have anything that you want to add. You're muted.
Apologies. Yeah, we saw this with the GDPR in Europe, where you see these DPO firms, or even the representative firms that sprouted up everywhere, and good or bad, they're looking at it in terms of seeing like, oh, how does this one guy know and understand 7 or 8 different businesses, right? We get that you understand data protection. We get that you can do all of those, tactical and operational things, but then it's about understanding the business, right? And so, like as Justine said, yet to be seen what happens here. I think more success is seen in appointing a DPO solely for your organization, and then perhaps having an organization providing, privacy office as a service, or outsourced, privacy expert on demand, where they're helping your DPO stay on top of things, but they're not at the point where they're making or solely making a decision as the DPO. But yeah, time will tell for sure.
Okay, I'll sneak in 2 more. Should we re-engage our data subjects / customers re-consent? James, you can go ahead or
Okay,
just.
yeah, sure. No, that's a great question. You know, I'll harken back to the days of when the GDPR came about. Reconsent was discussed. It's been discussed in you know, a lot of the guidance released by the European or EDPB, the European Data Protection Board. So reconsent is always good. The one thing I will say about consent is that it's always seems to be the toughest legal basis to provide proof thereof. You know, everything we do is always seems legitimately interesting, as a privacy pro would say. So legitimate interest is really one of the most common legal bases that organizations rely on, whereas consent is a little bit tough because the burden of proof, you know, lies on the organization. So I would answer that in terms of it would depend on how you're collecting the consent. Obviously, you know, that could be through some sort of email with affirmative action or web form with affirmative action. It is definitely a good idea to refresh consents, especially if that's what you're relying on. Then you have a valid way and a current way to prove. But just always remember, if there's anybody that's ever in this call that's ever done email marketing, somebody will sign up for an email list, forget about it, and a year later will mark you as spam and say that they never consented, right? So again, consent is super tough. But that's why I would say it's always a good idea to refresh consents, and maybe put that on a continual, you know, whether you're looking at 6 months or a year, but you're continually refreshing your consents if that's what you're using.
Thanks, James. And last question that we'll field: if a company is still open, but has ceased operations that involves data and data subjects, are they still required to register as data controllers?
So I think in that, again, this would be super situational, but I think in this scenario, you'd really have to ask, you know, they're still open. So that means they're still a business. Have they really no personal information whatsoever? That you'd have to ask yourself that question. When we say having personal information, it doesn't necessarily always point the finger at volume, right? You know, there's damages that could occur if one piece of personal information is breached or 100,000 records are breached, right? It's equally harmful to the rights and freedoms of an individual. So if that business truly no longer has any personal information, which would be kind of a tough one, then obviously, if you don't have personal information, you really don't need to register. You really don't need to demonstrate compliance. But if you do, you certainly should.
I just want to add it as well. Really, the question that James posed, I think, is very important, because if the company is still open and conducting business, I would presume that they may have employees, and that's often overlooked. So unless you are purely an asset holding company and you have no employees at all, a lot of people overlook the fact that your employees are data subjects as well. So just think about that as well in terms of whether or not they truly have no data subjects. I just want to also add something to the previous question. I was looking for my unmute button, but it escaped me. Consent is going to be, as James said, is challenging, but also challenging for some of the practical realities we face here in the Caribbean. I had a question about consent from a microcredit company who, you know, they go into rural areas, markets, and James, when you come down to Jamaica, we'll show you how it is, but it can be very informal. And for you to come to somebody and say, look, Miss Madge, I want you to consent to this, they're like, I don't know what that means. What do you mean by that? You know, so we have to really look at consent and how we are getting consent, because sometimes it may not fit the realities, and you may not have to look at a different ground. But if it's direct marketing, of course, you need to have some sort of documentary proof of how you've gotten the consent. And so definitely that consultation is important to just make sure that we're putting something in place that fits your realities, that fits the fact that you go out into the streets, into the rural areas, and you may not necessarily be dealing with persons who are tech savvy. So yeah, man, I will opt in. You want to be having something that is relatable and practical for your business operations.
Thanks, Justine. And the last thing I want to do is I'm just going to share my screen again and zoom in on this last slide, just in terms of before we close, and I appreciate the attention of everyone that's still here. It's just my computer, but we'll move on. So I wanted to just zoom in on the Compliance Readiness Program and those deliverables. So what are the deliverables? Just to go over them. So we can provide, and two keywords I want to zoom in on, right size and customized. We do not prepare programs for a one size fits all approach. It's the a very large organization or somewhere in the middle. It's always going to be right sized for you. So we provide a privacy gap and risk assessment, findings grid, as James mentioned, which will indicate where you have compliance or where you do not. Right, that's my computer normalizing again. Right, where you have compliance or not. The grid is particularly critical as it provides a very clear indication of where you have done well and where there's room for improvement. Then there's a findings report with actionable recommendations, a remediation plan and roadmap, and specific to those companies that need it, we can provide data mapping and records of processing activities or RoPAs. Last, but by certain no means least, if actual OIC registration is required, we can provide services through that with Hart Muirhead Fatta. If guidance on internal documentation and policies are needed, so for instance, you've developed a privacy notice, but you'd like it to be reviewed just to ensure that it complies with the Act, we can do that for you. If you need guidance on how your DPO should be appointed, who should be that person. There was a question in which Justine did cover in her presentation about the differences between a DPO, a data processor, a data controller. That will be clarified, as well as data subject access requests and data breaches. And I'd just like James to add his last points, just to emphasize DPSA's wealth of experience in privacy, as James would have mentioned, which he probably didn't give himself enough credit for. You know, he's vastly experienced with data protection acts across the world. So GDPR tends to be the one that we template most of all, but there are others, there are hundreds almost that exist throughout the world, especially in Asia, Latin America. So James, just to close us, I would like you to just give us, you know, just a few tidbits on DPSA's experience with privacy.
Sure thing. Yeah, so as Gracie would have indicated, we're active globally with clients all the way from the US to China and pretty much everywhere in between. The proliferation of privacy legislation is you know, ever more important, right? We're now, you know, we're seeing laws enacted, right? And we need to ask the question, do we become compliant? Unfortunately, in a lot of areas, when any law is passed, organizations, companies look at it and say, okay, what's the cost of compliance versus what's the cost of the fine? And it's very interesting. We saw this with the GDPR. If you look at the fines there, And even the fines with the Data Protection Act in Jamaica, they wanted to kind of put an end to that, right? So the fines are pretty steep, to the point where they could be an extinction level event should they be levied on companies. Specifically the GDPR, that's pretty heavy. And we've seen a lot of enforcement in Europe through the GDPR, with a lot of money changing hands. So definitely, our experience through all of that, we've been on both sides of a data breach. So by that, I mean, we've been there before one has occurred, and we've been called in after one has occurred. We've been on both sides of regulatory privacy, issues. So again, there before they've, before a client had any issues, and we've been called in after a client has had, complaints. So we have a wealth of expertise there. Our name, DPSA, data privacy and security. So we also are in the security realm as well, doing things anywhere from penetration testing, ISO certification. We are not a certifying body, but we do certification readiness programs. Again, very similar to this, where we put everything together and prepare you for your audit. And we have a 100% success rate with our ISO programs, so that's pretty good. But again, yeah, anything from HIPAA, healthcare finance regulations, we have a lot of those in the US. So there's also the Banking Act in Jamaica, so we're very familiar there. We can do assessments, we can help you demonstrate compliance. And our clients range from small businesses, 1 to 5 people, all the way up to 50,000 people, with a huge global footprint.
Thanks, James. I think affordable was the word that you wanted to add there.
Absolutely.
Yes. So as we close, I really appreciate everyone's attention. I still have 90 people on who've been with us since 11 o'clock AST or 10 a.m. EST. Really appreciate your attendance. I'd like to thank James and Justine for leading us through today. Shireen as well from the Jamaica Stock Exchange. And don't forget, data protection course is available. We will send you information on how you can get in touch with Shireen to apply for the course, to register. Additionally, I'd like to thank TCJ Events for their hard work and executing the event, and as well as the Calibra and internal DPSA and HMF teams. To everyone, a wonderful rest of your Wednesday afternoon, a wonderful rest of week. Please use the grace period effectively and efficiently. And if you need help, please don't hesitate to reach out. Thank you so much.